Hello, my name is Greg Corrales, and as the Children's Justice Coordinator for Maricopa County, a significant part of my job is to train you, mandatory reporters, on our state statutes and the county protocol, specifically A.R.S. 133620. This is the statute that outlines your duties as a mandatory reporter. This online course is designed to do just that, provide you with all the tools you need in order to make a report. Thank you for watching.
There's always one straggler. Come on in, have a seat. We're going to go ahead and get started. All right, guys. Well, welcome to your mandatory reporting class. Today we're going to go over A.R.S. 13-3620. Has anybody been reading up on their Arizona state law and happen to know what I'm talking about?
Any person who reasonably believes that a minor is or has been the victim of abuse or neglect shall immediately report or cause reports to be made to a peace officer or to the Department of Child Safety.
Nice. Somebody did their homework.
Yeah, it's in the course outline.
It is indeed. All right. Well, this one's not on your outline. Who is any person? In this statute, it states that any person with reasonable belief, but in this particular context, who are we referring to when we say any person? You guys had too much for lunch. You're falling asleep. All right. Sir, what do you do? What's your job?
Me?
Yeah.
I'm a teacher at the elementary school down the street.
Well, yeah, you are any person. And you, miss, what do you do?
Oh, I'm a nurse.
You are also any person. Right? Any person, as defined by Maricopa County Protocol, include medical health professionals, peace officers, clergy, DCS investigators, parents, guardians. I mean, the list goes on and on. So, are there any questions?
I think we got it. Any of us could be any person.
Yeah. And Margaret gets the gold star. All right, well, let's move on to reasonable belief, okay? A mandatory reporter must have reasonable belief before he or she can make a report to either law enforcement or DCS. Reasonable belief is acquired through facts, personal knowledge, and reliable third-party information. Ms. Paige, can you tell me how one might acquire reasonable belief?
Do you ask a lot of questions?
Yeah, that's right. More specifically, there are 4 open-ended questions that must be asked, no more and no less. Xavier, right?
Yeah.
Would you go ahead and read the 4 questions off the outline there for me?
Okay. Let's see. What happened? Who did it? Where were you when it happened? When did it happen?
Shouldn't we ask more in-depth questions?
Not a good idea. From the perspective of an officer of the law, asking questions beyond these could contaminate or spoil an investigation.
Precisely. Yeah.
I guess that makes sense.
And it's also important to remember that reasonable belief can simply come from a gut feeling, right? It's a very, very low standard, the lowest of standards.
So we don't have to be certain that something took place.
Establishing a standard of belief beyond a reasonable belief is the job of the investigator, not the mandatory reporter. All right, so can anybody sum up this part of the law for me?
We can only ask the 4 questions listed.
The standard of reasonable belief is low, and a gut feeling really is good enough.
Great job, everybody. So yeah, we're going to move on to the 3rd element of the statute, okay? An individual must be a minor who is the subject of a past or present abuse before a mandatory reporter's duty can be triggered. And just to be clear, guys, past or present abuse occurs when an individual is under the age of 18, okay?
Question. Yeah. What types of abuse are covered by this statute?
That's great timing. I was just about to go into that because it is important to understand the difference between abuse and neglect, okay? Physical abuse occurs when an individual intentionally harms a child or minor. It's not caused by an accident. Physical abuse can also be caused when there's no physical touching or physical contact involved. Officer, would you care to provide an example, please?
Yeah, well, we had a case once where we had a parent who was intoxicated and had an accident, and several children were injured and had to be treated at the hospital. It could have been a lot worse.
Yes, thank you, officer. And as an officer of the law, I'm sure you're well aware that an individual who's intoxicated or under the influence is also an example of physical abuse. Yeah. Okay, can someone tell me the definition of sexual abuse?
Sexual abuse is any sexual act between an adult and minor or between minors.
And I read that sexual abuse can occur when no physical contact has actually been made.
Good point. Yes, acts such as exhibitionism, exposure to pornography, voyeurism, sexual communication through internet or phone are all examples of sexual abuse. Okay. Would anybody like to take a whack at emotional abuse?
Give it a go. Isn't it when serious emotional pain and suffering is inflicted on a minor in such a degree that it hurts them?
Well, that's definitely part of it. With emotional abuse, there has to be proof that the alleged perpetrator caused the harm, right? And the harm has to be of such an extent that it's evidenced by medical or psychological diagnosis.
I get that, but what does it have to do with neglect?
Neglect is the inability or unwillingness of a guardian to provide the basic needs, such as supervision or food, clothing, or medical needs, if it causes reasonable risks of harm to the child.
Very good. And the star student takes it again. That's right. Guys, when we're talking about neglect, we're not talking about poor parenting or bad life choices. We're talking about a specific act against a child in the form of neglect. Okay?
I have a question.
Yeah, go ahead.
So once a reasonable belief has been established, when do we report this?
That is referred to as reasonable immediacy. Okay, reasonable immediacy is sort of a balancing act. An individual must make a report to the appropriate agency when it is professionally possible, safe, and appropriate. Okay? Oh, and it also must be done with a sense of urgency as well.
So, is the appropriate agency the Department of Child Safety?
Yes, yes it is. And you can use the same phone number that's been provided to you from this class.
You can also call law enforcement on the non-emergency number or dial 911.
Thank you. And on that same point, Maricopa County Protocol suggests that you always contact law enforcement or DCS if you feel that the alleged perpetrator is the parent or guardian or caregiver.
And if you're not sure, call both.
Also, never tell the parent or guardian that you've just contacted law enforcement or DCS. Simply refer them to the agency. And don't worry about your own liability. The Arizona State Legislature has created the Reporter Immunity Clause, in which any person who makes a report in good faith is immune to both civil and criminal liability.
Well, between the law of immunity and the low standard of reasonable belief, it does make it easy for any person to report abuse.
Yeah, you got it. I mean, the legislature has removed any hurdle or obstacle, really, for reporting. And on the flip side, it's also a legal obligation to report. Failure to report an abuse is a crime.
Failure to report sexual abuse is a Class 6 felony. It could result in 2 years in prison up to $150,000 in fines. Failure to report any other type of abuse is a Class 1 misdemeanor that could result in 6 months in jail and up to $2,500 in fines.
Thank you very much, officer. That's going to be it for the class. Thanks so much for coming. I hope you all learned something.
Thank you.
Absolutely.